I would now like to welcome the President of the Legislative Council, the Honourable Mr Ben Franklin, to open tonight's event. Thank you, Mr President.
Well, thank you very much, Hayley, for that very warm welcome. And it's my great pleasure to welcome you all here tonight for Parliament Unpacked, Privilege, the Parliament's Sword and Shield. Before I begin, I'd like to acknowledge the traditional custodians of the land on which we all meet tonight, the Gadigal people, and to pay my respect to elders past and present and thank them for their custodianship of this land for many tens of thousands of years. And I do just want to take a brief moment to talk about that. I'm mindful that this Parliament has a complex and varied history with Aboriginal people in this state. Some of the decisions that have been made in this place since 1856 have had very serious negative ramifications for Aboriginal communities, while others have signalled really positive change and ensured that Aboriginal voices can be heard at the highest levels. But by acknowledging country in Parliament, we aim to continue to break down the barriers and build trust across the communities in this state. The Parliament of New South Wales strives to work alongside Aboriginal communities, to listen to their voices and to build a better future for all people in this state. And while you're here with us tonight, after this incredible event, I do encourage you to enjoy our latest Fountain Court exhibition, which is presented by the Bamali Aboriginal Artists Cooperative. We set up the Reconciliation Wall 25 years ago, which was to always show Indigenous artwork. This is the 25-year anniversary. They were the very first exhibitors, and there is quite an extraordinary exhibition out there which I encourage you to have a look at once tonight has ended. But tonight we meet in the Preston Stanley Room. Some of you may not have visited this particular room in the Parliament before. It's often used for events and committee hearings, and it was actually named for the first female member of the New South Wales Parliament, Millicent Preston Stanley, who was elected to the Legislative Assembly in 1925. She was among the first women in New South Wales to become Justices of the Peace, and she served as President of the Women's Justices Association from 1923 to 1926. Throughout her life, Preston Stanley advocated for women's rights, health reform and abstinence from alcohol. Preston Stanley addressed her colleagues in her inaugural speech with the following words. Some honourable members have been kind enough to suggest that women should be protected from the hurly-burly of politics. This attitude of mine may do credit to the softness of their hearts, and I think it also may be taken as prima facie evidence of a little softening in their heads. She went on to say, I believe that women's questions are national questions, and that national questions are women's questions. And it may be shown that a woman can take her place amongst the representatives of the people in the Parliament of the country and play her part in the political life of the nation. This room, the people in this place and this institution over decades and generations have so many stories to tell, so many firsts of our state. Robust debates and complex conversations have taken place here for generations. And tonight we'll be delving into another unique aspect of this place, parliamentary privilege. Parliament Unpacked is a series of events the Parliament's communication, education and engagement team organised to provide the public with insights into the workings of Parliament itself. Tonight's Parliament Unpacked topic captures the power of privilege, referring to privilege as the Parliament's sword and shield. Now, the word privilege in this place has a very different meaning to its common everyday use. It has a long history that parallels the development of the Westminster parliamentary system. Privilege refers to the rights, immunities and powers of the Parliament. It is one of the more important principles that underpins our Parliament today. It connects kings of the past with the members of the present. And tonight you'll hear about the historic breach of parliamentary privilege in 1641 when King Charles I attempted to arrest members of the House of Commons. You'll also learn about modern practices and interpretations. You're incredibly fortunate to have two genuine experts on Parliament and privilege in this nation to discuss the history and practice of this deep and interesting topic tonight. We have on my far right Mr. David Blunt AM, who is the Clerk of the Parliaments and the Clerk of the Legislative Council, and sitting next to him Ms. Helen Minikin, Clerk of the Legislative Assembly. I have the incredible honour of working alongside both Helen and particularly David in my role as President of the Legislative Council and as a member of the Parliamentary Executive Group. And I can assure you this, that to be in their presence and to have access to their minds this evening, their candour and their experience is truly a remarkable opportunity. I know that tonight will be a highly engaging and informative discussion for everyone, and I sincerely hope that you will all enjoy tonight's Parliament Unpacked and gain a much greater appreciation of all aspects of parliamentary privilege. Thank you so much for being here tonight, and I'll now hand back to Hayley.
Thank you, Mr. President. Thank you, Mr. President, and thank you to David and Helen for taking the time out of your busy schedules to share your knowledge with all of us here tonight. Now, for parliamentary privilege, there might be some people in the room who know quite a bit about it. It might be new to some as well. So we're going to begin with the basics. So the word privilege has certain meanings and connotations in everyday use. But in a parliament, Helen, can you tell us what does the word privilege mean?
Yes, thanks, Hayley. Well, picking up a little on what Mr. President just referenced, it's rather unfortunate that you have a dictionary definition for privilege that means entitlement and an advantage, because in a parliamentary sense, parliamentary privilege is quite different to that. It does involve some special rights that members of Parliament enjoy while they are members of Parliament. But as the President referenced, it's really about rights, powers and immunities that are actually held collectively by the House and enjoyed by individual members. But those rights, powers and immunities are solely for the purpose of enabling Parliament to perform its functions effectively and to be able to legislate, deliberate and scrutinise the executive. It isn't owned by individuals, individual members. It's for their personal benefit, and it belongs to the Parliament as a whole, belongs to each House, and it is intended to be a protective tool. There's some, the most famous or the most well-known parliamentary privilege is freedom of speech. So most people will recognise that anyone who's participating in a parliamentary proceeding, be it in the House, in the chamber, or in a committee as a witness potentially, that they are afforded the right of free speech. And I think essentially what you are seeing there is that people can participate in the democratic process, in parliamentary processes, without fear of litigation. There's some interesting things that we do at the beginning of each parliament. So we've actually just commenced the current parliament at the beginning of this year in May. And so from my perspective, there are some quite traditional elements of the day that reference parliamentary privilege and its importance historically, which David's going to talk a little bit about shortly. So, the Speaker at the beginning of the Parliament lays claims to the privileges of the Legislative Assembly when he meets the Governor for the first time. So that's sort of, that's quite entrenched and embedded in long traditions and customs out of UK law. I think the other way I tend to look at parliamentary privilege generally is that it is one way that defines the legal relationship between the different branches of government, being the executive, judiciary and the legislative branch. So probably on that particular note, I'll probably leave it over to David. There's other things apart from freedom of speech. There are certain privileges such as the privilege to conduct, regulate and control the proceedings of the House. The House has ultimate authority for that. The power to conduct inquiries is another one, which David also may be talking about later, but I think that's probably enough from me. Yeah.
Yeah, so I think it's pretty clear that while privilege is just one simple word we might use in particular ways today, here in a parliament, it's very complex. There's lots of moving parts to it as well. So that's what you're in for this evening, everyone. David, we've heard a bit from the President about the history, certain parts of the history of parliamentary privilege. Can you tell us how parliamentary privilege began?
Thanks, Hayley. And like most of the questions you'll be asking this evening, there could be an hour-long discussion in relation to every single question. So I'll try and keep this to 2 minutes. But Helen touched upon the relationship between Parliament and the other branches of government, Parliament and the executive, and Parliament and the courts. So I think what we saw develop in Westminster over centuries was firstly the relationship between Parliament and the executive. That was, in those days, Parliament and the King. So in the 16th and 17th centuries, we saw disputes between Parliament and King. We'd see the Parliament called together by the King, mainly from the King's point of view, for one purpose, that is to raise revenue for the King. And then the King would have been happy for the parliamentarians, members of the House of Commons, to go home and that be it. But they continued to meet, they continued to debate matters, including debating controversies about members of the royal family, passing motions, giving speeches that were critical of the King and the royal family. And that led to, for instance, attempts by the King to arrest members of Parliament. Mr. President referred to 1641 and King Charles I entering the Parliament. This dispute, it took about 100 years to resolve, and it was a bloody resolution. We saw King Charles I lose his head. We saw the English Civil War. 1 in 5 adult males in England died during the English Civil War in the 17th century. Eventually, we saw the matter resolved by the passage of the 1688 Bill of Rights, including famous Article 9, which says that proceedings in Parliament cannot be impeached or questioned in any court or place out of Parliament. Basically, Parliament won the dispute. Parliament was sovereign in relation to the Crown. Then we saw over the 18th and 19th centuries a dispute between Parliament and the courts. Parliamentarians, having sort of won the battle with the King, started to sort of really push the boundaries as to where their powers lied. For instance, asserting that they were immune from being prosecuted from criminal offences, or, for instance, injuring a trespasser on their estate who'd come in to shoot pheasants or something, that they could not be arrested or prosecuted for those sort of things. Well, the courts did not take kindly to that, asserted that the rule of law applies to everyone equally in the land. And so we saw over many years that dispute take place, eventually resolved in a series of landmark court cases. So there's one famous one in England that involves Hansard. There's a famous one in Australia from the 1950s that has the same result in terms of the legal principle that it sets out, which is this, that for a parliamentary privilege to exist, the courts must actually recognise that it exists. Once the courts recognise that a particular privilege exists, then Parliament can go about exercising that privilege in the way it sees fit, but it has to be recognised at law.
Interesting. You've been able to cram the few centuries of history in there. Thank you, David. And as I understand it, though, I'm very happy to be corrected by the clerks, we've inherited from the British Bill of Rights, Article 9, privilege here in New South Wales. So do correct me, Helen, if I was wrong there. But are there any other additional sources of privilege in New South Wales?
Yes, so New South Wales is a common law jurisdiction in terms of parliamentary privilege, unlike all of the other Australian states and territories. So Parliamentary privilege here is defined at common law, and at common law we only have such immunities, rights and powers as are reasonably necessary for the existence of each of the houses and the proper exercise of their functions. So this is a principle known as a principle of reasonable necessity. We also, in addition to Article 9, which as Hayley has correctly referenced, it's incorporated into our statutory law under the 1969 Imperial Acts Applications Act. And that particular Article 9 says that freedom of speech and debate or proceedings in Parliament ought not to be impeached or questioned in any court of law, in any court or place out of Parliament. And there's about several questions in there that David might be talking about shortly that make that particular Article 9 not, it's quite a nuanced piece of a statutory basis for parliamentary privilege, and it's not without a lot of interpretation that goes into it and a lot of potential justiciability as well. Pardon me. So the other aspect of privilege that we have in New South Wales is a certain number of statutes that also provide for it. So there's the Parliamentary Evidence Act, the Defamation Act, the Parliamentary Papers and Supplementary Provisions Act. So this legislation gives you certain defences under defamation law for things that you may say within parliamentary proceedings that are potentially defamatory. They provide for the power to publish documents and evidence that's laid before each of the houses, and those statutes also provide powers to require the production of documents and material, to compel attendance of witnesses, and penalties for refusing to answer lawful questions and knowingly giving false evidence to committees. So there's a very interesting inquiry. I'll give David's house a plug. They're doing a current inquiry before the Privileges Committee in the Legislative Council on the Parliamentary Evidence Act, and there's also other aspects of it that have been referred to another of the council committees in relation to ministerial accountability. So for those parliamentary officers here, most of that is essential reading in my book. So yeah, look, I think they're the main aspects I wanted to sort of explain, that we are a little different to, if you go straight to the House of Reps and the Senate and you look at Commonwealth authorities, we are still quite different. I have some personal views about that. I'm a great fan of common law and flexibility, but yes, it's not without its challenges, and it makes for the significance of cases is something that we have a lot of regard to.
Thanks, Helen. And as a parliamentary officer here, I probably need to do some reading. So thank you for the reminder. So a couple of times now you've referred to the word proceedings. They've come up a few times. So David, parliamentary privilege applies to the proceedings of the House. What exactly does that refer to?
Article 9 uses the term proceedings in Parliament, so it's important, as Helen's already touched upon, to note that it's about things that happen in a House of Parliament, but also in committees. So it's equally applicable to parliamentary committee work. On one level, it's almost obvious the sorts of things that are covered. It's like votes in Parliament, speeches that are given, motions that are moved, petitions being presented, documents being tabled, evidence being given before a parliamentary committee, submissions to a parliamentary committee. So on that level, it's fairly obvious. It's also worth noting that the Commonwealth Parliamentary Privileges Act, Section 16(2), has a definition of proceedings in Parliament. Now that doesn't apply as the law in relation to the New South Wales Parliament. Nevertheless, it's useful guidance. It's regarded as a good statement of parliamentary privilege. So that's the sort of the obvious answer to your question, Hayley. But of course, with everything with parliamentary privilege, there's nuance and there's debate on the edges. So if anyone would like to delve into these issues of what is a proceeding in Parliament in depth, more than happy to chat about that afterwards, but I would refer you to reports of the Legislative Council Privileges Committee, particularly in relation to one of our former members, the Honourable Peter Breen, back in the noughties, about 20 years ago. And most recently, there are a series of 5 reports in relation to matters connected with the former member, the Honourable Shiket Musulman, which have, between the two of them, those 2 sets of inquiries, and I think 7 reports in total, Stephen Frappel, I'm looking for sort of 7 or 8 reports, which unpack the meaning of proceedings in Parliament.
Great, thank you. Now we all know that. Helen, you did mention before freedom of speech. So why is freedom of speech important to the Parliament, to the members and to the public?
I can only envisage this in a short answer, even though it's so incredibly important at so many levels. But I think free speech is about any individual, be it a parliamentary officer like myself, a witness, a member of Parliament, being able to freely and fully participate in an unfettered way in proceedings and not to have that fear of litigation hanging over them. At different levels, it's also about, if you put the history to one side, and I think there's some very good books around that unpack the development of parliamentary privilege, which, as David said, if you look at it in context, it has a lot more clarity around it. But in a modern democracy, I think the significance of free speech is that there's the preparedness of citizens to be able to participate directly in parliamentary proceedings as witnesses, as submission makers, the ability of members to, without hesitation, represent the interests of their constituents, to be able to challenge the workings of the executive and executive decision making, and that sort of fundamental trust in the democratic institutions and the system of government in the state does rely on Parliament being able to function properly. Now, that's not to say that there aren't inbuilt disciplines around free speech, that there aren't obligations on the parts of members and other participants, or that the houses don't actually self-regulate to a degree and put in place their own rules around responsible and appropriate use of free speech. But it is a robust and environment in which to work, and in proceedings should be able to be robust in a strong democracy if you value civilised discourse, I suppose.
Which I imagine everyone who joined tonight would agree. We've talked a few times about that the houses have the right to control their own proceedings. So my question for David is, why is that? Why can't I just come in from the public and join the debate in the chamber if I want?
That's a good question. I think on the one hand, simply because you haven't been elected by the people of New South Wales, unlike our members. I mean, they're in a very special position because they've been elected by the people to do things. They've been elected by the people to be responsible for legislating, for keeping our laws up to date, for scrutinising whether those laws are effective, and also for keeping a check on the executive government and holding the government to account. I would say, though, that very, very occasionally non-members do get to participate. I mean, of course, non-members get to participate by contributing to parliamentary committee inquiries, by making submissions and giving evidence before committees. Again, this is probably getting into the nuanced territory and detail, but there is provision for something called a citizen's right of reply. Sometimes members, in the exercise of this really important freedom of speech, may say something in the House which causes offence. They may say something that some members of the community, a member of the community might think is actually wrong in terms of fact. And so both houses here, as have a number of other houses around Australia, have put in place provisions for a citizen's right of reply. the Legislative Council tends to have a fairly liberal approach to how that's applied, and we've had that for some time. Nevertheless, it did take many years for that system to be put into place, and I think that's symbolic of just how careful one has to be with any tinkering or changing of anything in relation to parliamentary privilege, and our members were very careful in the way they crafted that system for citizens' rights of reply.
Great, thank you. We're going to pause here for a moment. You can have a glass of water. We've been talking for a little bit now. I'm just going to tell a short story about a time where someone from the public did interrupt proceedings in the House. It does occasionally happen, of course. This is a historic occasion, though. This is just going to be a story to demonstrate that while this is an issue, even if the person's cause is just their reason for interrupting proceedings in the House. So this particular story comes from 1938. There had been questions for many weeks in question time in the Legislative Assembly related to a British woman named Winifred Guy. I'm just going to put her up on the screen. It's a bit hard to tell. It'll make sense in a minute. She was somewhat known in the community. She actually had a nickname. She was called the Poster Girl. She had this name as she exhibited and created posters showing all the highlights of the Commonwealth at the time. She'd create these posters and then use them in education purposes, so like in a classroom. She also travelled around the world and wrote in magazines about her experience, so maybe a bit of a 1930s influencer of today. And she knew that her posters were actually being used in schools here in New South Wales, but she hadn't been compensated for her work. So after being ignored by the Minister for Education for a few weeks, she decided to take things into her own hands. So in the Legislative Assembly chambers in 1938, she stood up in the galleries, called into the chamber, "I hold the House and I ask for justice." She then proceeded to give her own speech in the middle of question time. When the Sergeant-at-Arms at the time attempted to remove her from the House, they discovered that she had chained herself to the railing of the public gallery. She continued to address the House with her own speech for 10 minutes before she was cut free with a pair of wire snippers and escorted from Parliament. And we can see Winifred Guy on the screen. Afterwards, she met reporters outside Parliament who took this photo to show the padlock and the dog chain she had used to chain herself to the ladies' gallery on the rail of that in the Legislative Assembly. Now, Ashley was never able to find out whether she was compensated in the end for her work. I can tell you that it was reported the next day in the Sydney Morning Herald that she attended question time again in the Legislative Assembly. However, she remained silent in the gallery and the business of the House continued unimpeded. So I don't know if she wanted to have a citizen's right of reply. I don't think it would have applied in this particular context. There are more scandalous details associated with this story that have been told over the years. Some people in the room who work at Parliament might have heard these details. I think they're unsubstantiated, including when the Sergeant-at-Arms asked for the key to her padlock, that she hid it in her undergarments. That was not reported in the papers at the time. And another detail was that she actually swan dived into the chamber. If anyone's familiar with the chamber, that would have been quite a distance. She definitely would have hurt herself. That was also not reported at the time either. So I just wanted to demonstrate something that could happen in the House, but obviously the actual business of the House could not continue while all this ruckus would have been happening. None of this is recorded in Hansard either, because it is not the official recording of what occurred that day. So going from one fictional story just then about her undergarments to another fictional story about Parliament. The next thing we're going to do is show a short scene from ABC TV show Total Control that's related to parliamentary privilege. Do we have any Total Control fans in the room here tonight? I think if we've got some people who are interested in Parliament, I'd highly recommend watching Total Control. For the uninitiated, Total Control stars Deborah Melman as Alex Irving, who is the captain picked to fill a vacant seat in the Senate by the Prime Minister, played by Rachel Griffith. The series follows the new senator's experience as an Aboriginal woman new to Parliament and to the world of politics. A bit of spoilers I've got for you. The first thing is that part of season 3, which isn't yet aired yet, actually was filmed here at the New South Wales Parliament. So wait to see that next year. And we will be showing a short clip. It's literally 1 minute long, but it does have major spoilers for the first season of Total Control. We're only playing a short scene, but it is a critical one. So if you want to stick your fingers in your ears for 1 minute, we'll play that now. So, when it comes to parliamentary privilege, what did Senator Irving perhaps do wrong?
Well, I think I could ever say that the Parliament did anything wrong, but I think from David and my perspective, when I first saw that scene, I thought it was, in terms of things like parliamentary privilege, it's quite fascinating. So for the period that Senator Irving is in the House, she has parliamentary privilege for all of that statement that she made. She then steps outside the chamber. So she's no longer participating in proceedings in the House. And then you fall back on, if you are making potentially defamatory statements, things like the statutory defences that are available for you under the defamation law. Doesn't mean that defamation proceedings can't be commenced against you, it just means that you have those defences available to draw on. But having said all of that, there are other defences apart from absolute privilege. There's qualified privilege, which I think you've got some questions about later on. So, for members, it's weighing up a whole lot of considerations that they balance. And in that particular scene, the Senator would have been considering that she had incontrovertible evidence of potential criminal offence in her eyes. So, yeah. I think, there's a very famous New Zealand case called Buchanan and Jennings, which is called effective repetition. That's the sort of issue that arose out of that. And it really was about a member who made some defamatory statements in the House in relation to, I think, a rugby tour and the participation of some official who possibly misused public money to take a friend on the tour.
It was a very New Zealand case.
It was.
I think it also involved the wall board
yeah,
or something.
Exactly. Sheep, rugby, all that stuff. So, yes, and so what happened was afterwards the member actually gave an interview, and during the course of that interview said, I don't resolve from anything I've said in the House. And this was the effective repetition element. In effect, they had repeated the defamatory allegation that they'd made with the benefit of parliamentary privilege.
Not about your question, but about total control. I've got to say, it was a real thrill to have the third season of Total Control being filmed here at Parliament, and there was a lot of celebrity spotting going on during the filming. I went out for a run one day, and as I was coming back in for a run, I literally bumped into Wayne Blair, who plays a very important character. I won't spoil season 2 for those of you who have not watched, but when I came in for my run, I couldn't help but address him by the title that was due to him at the end of season 2, and he looked at me blankly, and he gave nothing away. So I'm really wondering what's going to happen in season 3.
So we've got at least one person watching, but I hope we make some more fans here tonight as well. Now, the first part of what we were talking about, I promise you, is actually all the basics of privilege. Helen and David, they have brought notes with them tonight. They have standing orders. They have books on procedure and privilege. So now we're going to go a little bit deeper. Helen just touched on this, and we'll talk about this now. As you said, when members are involved in the proceedings of the House, they have absolute privilege. What are you referring to when you say absolute privilege?
Yes, so this is where terms in statutory provisions are very important. So if you go to Section 27 of the Defamation Act, it talks about the defence of absolute privilege, which is one of several sorts of defences available to somebody who's the subject of such proceedings. Now, the words used within the construction of Section 27 relate directly to all of the things we've talked about in terms of your participation in proceedings. So it talks about the defence being available to the defendant if they can prove it was published on an occasion of absolute privilege. And without limiting that, because this absolute privilege isn't limited, publication in the course of proceedings is of a parliamentary body includes, but once again isn't limited to, anything that is published by order or under the authority of the body. That includes publishing debates and proceedings. That includes while you're giving evidence, not when you leave the room and step outside and may be confused and think that I've just given evidence to that committee, so everything I've said is all covered. That's not how it works. You actually have to be in the moment, in the proceeding. And then, it goes on to talk about while you present or submit a document to a parliamentary body. So while you're potentially as a witness making a submission to a committee. Now this becomes quite fascinating because, in previous days it would have been that you would be doing that physically. Now you do that electronically a lot of the time via portals and websites that the parliamentary committees set up. And when it talks about publication, if you're in another jurisdiction, there's a reciprocity principle also encapsulated in the absolute privilege provision, which says that if the matter is published on an occasion that if published in another jurisdiction would be an occasion of absolute privilege, then under the provision of law of that jurisdiction, this section corresponds to that. And that's why I think it's important to think about the uniformity aspect of defamation law. And we have had some very chilling effect decisions in recent times for members that have given a lot of have raised a lot of questions around how members do deal with publications. There are 93 members in the Legislative Assembly. They're all publishers. They're all utilising social media. So decisions such as the one in the case of Vola, where there were implications for people who may set up a post on social media and then be subject to potentially defamatory comments being posted to their own personal website, whatever, by third parties. All of these sorts of things are matters that impact the freedoms with which members can participate in proceedings and anybody else for that matter. So yes, I think looking at the actual terms of the legislation and thinking about those principles and how it all connects up is very important.
So there's some elements of absolute privilege, and we talked a bit about qualified privilege there as well. So.
Yes. So qualified privilege is another privilege defence available to you under the New South Wales Defamation Act. There are other ones, defences for fair reports of public reports of public concern. But anyway, the one about qualified privilege does actually mean that you do start looking at the motivations of the individual who might want to claim that defence. And there are a number of sort of threshold requirements that you need to achieve if you want to have that defence available to you in a valid sense. You have to be able to prove that the recipient had an interest or an apparent interest in having the information or on a particular subject, that the matter that was published to the recipient in the course of giving it to them, that's you did publish it to the recipient, and that your conduct was reasonable in the circumstances. So, these are all open to interpretation and determination in the courts. I think the other aspect of it that's quite significant is that the publication, you must be able to prove that the publication of the defamatory matter was done without malice. So that those elements aren't present in the defence of absolute privilege. That's about that.
So let's pretend that I'm a member of Parliament. I've spoken an accusation against another person or group while in the chamber, so I'm protected by privilege. If I post the speech that I made, the video on my Facebook page, what are the consequences I might need to consider? It's probably for both of you.
Well, Hayley, I'm glad that you've come to me for advice before you've decided to post that information on your social media rather than afterwards. I would advise you to be cautious, exercise caution, because as Helen said, although you have absolute privilege for what you've done in the House, for what you've said in the House, absolute privilege there. You cannot be liable for defamation for what you've said in the House. You cannot be prosecuted for an offence if, for instance, you've breached a statutory secrecy order or something like this in speaking truth to power, as you've done in your very powerful speech in the House. But in considering what you're going to do next, bear in mind that you'll only have the defence of qualified privilege if you do post something on your social media platforms. So you need to be very careful. My advice to you would be that it's such a powerful speech, everyone's talking about it, do nothing. Let the media, let the public find it themselves. Parliament's Hansard publication page is very user-friendly. It's really easy to find things on the Parliament's website. Just let the media and other people find it. Don't do anything about highlighting it for them.
All right, so you can now look for my speech somewhere online. You know how to look for it. So, Helen, if there's a need to make a determination on a question on privilege, who can investigate that?
Well, it's called the Powerful Parliamentary Privileges Committee, as of some recent newspaper articles in the Herald. So both houses have members from across the chamber who comprise their respective parliamentary privilege committees. Ours in the Assembly is also called the Parliamentary Privilege and Ethics Committee. So that's one way that a breach of privilege or a question around privilege can be inquired into, and the House can make a referral to that, to one of those committees. I think David's committee probably operates in a very similar way to the Assembly committee in terms of obtaining referrals. The House is the ultimate arbiter in making a decision about whether or not there's any question of privilege that needs to be resolved. I think the other aspect of this is that when I said in the past that there are ways in which the houses can self-regulate. One of the ways in which the houses deal with questions of parliamentary privilege and try to strike balances between bodies that should be able to obtain information that may be held by members or the parliamentary administration in appropriate sense, is that they can make express statutory provision to regulate that area. And so, for instance, a good example of that is Section 122 of the ICAC Act, which has been amended to enable the Commission to access what's called the Pecuniary Interest Register, a register of the financial interests of members, which David and I both maintain as registers. So they can, for a specific purpose of an investigation, utilise the information in that document, which you could potentially have had questions of privilege raised about. So there's sort of, deliberative forums that each house sets up, if you like, that can take privilege questions away and look at them in a lot closer detail. I think in our Assembly rules, the Speaker once again has an interesting role in relation to matters of privilege. He sort of serves as a bit of a gatekeeper. So if it's a privilege question that suddenly arises in the House, the standing orders provide that the Speaker must make an evaluation, must make a determination as to whether or not there's a prima facie case. Is what he's actually looking at and being advised as a matter of privilege suddenly arising that? Or is it that the member is frustrated and actually doesn't have a point of privilege but really wants to speak for a maximum up to about 10 minutes on the things that he didn't get across in the debate? So the Speaker has this sort of quite interesting role in providing guidance to the House and the members and making rulings on those things. And then he does the same thing in relation to a matter of privilege that doesn't arise in the House but might arise outside. So, a member might say, look, I've been obstructed as a member of a committee, I've got some person hassling me and I can't properly do my job on the committee. So he has a specific sort of process to observe in that, and the same sort of thing does apply in the citizen's right of reply, that our speaker is a first port of call for requests along those lines as well. So yeah, I don't know if that's the same for yourself. Yeah.
Similar, although the President doesn't tend to have such an active role as a gatekeeper in relation to privilege matters. They're generally referred by a resolution of the House, by a simple notice of motion being given, etc. Although the President can refer matters to the committee as well. But,
that's how we
otherwise,
get them. But so the rules do provide for it, and we in the Assembly we do get matters of privilege suddenly being raised that aren't really matters of privilege.
Yes.
So there's quite a few rulings about that from speakers in the past. Thank you.
So we've mentioned standing orders a few times. I'm going to ask this question to David. There's one standing order from the Legislative Council that's quite well known. If there's some public servants here, you may have heard of Standing Order 52, the power to source papers. How does this standing order relate to parliamentary privilege?
Well, of course, Standing Order 52 is related to the power of the House, the similar power that exists in both houses, to order the production of state papers, to order the government to produce to the House documents about either a decision of government or something that's happening in a particular portfolio. It's a power that has been recognised at law. It's been recognised by the courts, so it's part of the common law. And Standing Order 52 is the set of rules that the Legislative Council has put in place to regulate the way it exercises that power. So there's a framework to administer each of those orders for papers.
Thank you. And do you have anything to add, Helen?
Just keep your eyes on the 58th Parliament, probably. We have had our first order for papers since about 1999. So it's a very interesting Parliament. And I think David's House, the Council, has developed a lot of processes around that. There's a part of how you approach privilege issues does rely on the practice and the precedent of the House that you're in. So prior to the last episode, before we did that, there were about a dozen cases, I think, in the early 90s, about 94, and they didn't have all of those processes to follow. So privilege, the interesting thing about privilege is that it does change and develop and adapt. So it could be the case that, at some point in time, how we might be dealing with orders for papers in the Assembly might change, but at the moment, we're following a lot less in the way of instructions around them, but the same powers do exist.
Thank you. Now, I was going to ask David about a particular High Court case, but we are running a bit shorter on time, and I think you said you could talk for about 2 minutes or 2 hours on this, so we might lean towards 2 minutes.
I'd love to have the 2-hour option.
So, maybe a future talk in the future.
The famous case of Egan and Willis and Carl from the High Court of Australia from 1998. Helen's mentioned that during the 50th Parliament there were a number of orders for the production of state papers made by the Assembly. In the next term of Parliament, the 51st Parliament, the Council started to copy that practice and made a number of orders for the production of documents. Mr. Egan was the leader of the government in the Legislative Council at the time. He refused to comply with those orders, and the House, over a period of months, censured him, found him in contempt of the House for refusing to comply, and ultimately suspended him from the service of the House, not as a punishment, but as a means of getting him to change his mind and to comply. The President at the time was Willis, the Honourable Max Willis. The usher of the Black Rod was my good friend Warren Carl. So when Mr. Egan was suspended from the service of the House, Willis instructed Carl to escort him out, to take him out of the House and actually onto the footpath of Macquarie Street. Mr. Egan took Willis and Carl to court, initially to the Supreme Court, lost, went all the way to the High Court. Mr. Egan's key argument was that, yes, I would have complied with these orders for papers if they were made by the Legislative Assembly, because the government is only really accountable to the Legislative Assembly. That's where government is formed. Government's not formed in the Legislative Council. As these orders were made by the Council, I don't really have to comply with them. The High Court said, by 6 judges to 0, the Legislative Council and the Legislative Assembly does have the power to order the production of documents because it's reasonably necessary in order for the House to be able to fulfil its roles properly, its roles of making laws and holding the government to account. It needs access to this information to be able to do those jobs effectively. So that's Egan and Willis and Carl in hopefully 2 minutes.
Yeah, no, well done. Thank you. As I said, we'll give you an opportunity, I'm sure, at a future time. My final question for you both this evening. Parliamentary privilege has been described for decades as a sword or shield, and that's what tonight's event is called. What's the metaphorical meaning behind those terms when it comes to privilege?
Well, I did actually try and find the source for sword and shield and how it was applied, and I'd be grateful if anybody else could find it because I couldn't in the time I had available. I think it's a shield in that it's protective. So but it's protective in a specific, defined way that is appropriate for what it needs. It's not all encompassing as a protection. Parliament's not a sort of statute-free zone, and members can't use, there's some famous UK cases, members can't use parliamentary privilege as a way of avoiding criminal charges and things like that. So it's an appropriate sort of protection, and I suppose it's a sword in the sense that it gives the weapon or the means for the Parliament to be able to scrutinise the executive and hold the government of the day to account. It's pretty much where I landed.
Yeah, I'd agree fully with that formulation of the sword, and then the shield being the shield to allow members to do their job, to do it effectively when they need to. Most speeches that members make in one or either of the House, they're not defaming anyone, they're not doing something that would otherwise be somehow a criminal offence. But it's just occasionally, maybe each member, maybe once a year or once every parliamentary term, needs to speak truth to power. And in order to really speak truth to power, they need to be able to do it without being subject to proceedings for defamation or other criminal proceedings arising from that. So that's what the shield's about, protecting the parliamentary institution to be able to do its job.
Yeah, thank you. So for those who have been sitting here for the last 45 minutes wondering why it was called that name, thank you so much. Now, thank you to you both. It's been a real privilege to talk to you tonight about privilege, and you can thank my restraint that I didn't do that more times than about this evening. So that's all the questions that I have for you both this evening. Thank you very much. I'll now turn to the audience. If anyone has a question, if you want to put your hand in the air, I've got a few people on microphones who are happy to take some answers. Yeah.
First of all, thank you very much both for your insights. I also feel that it's been a certain privilege to be here. Do you have any recommended books in terms of further reading we can do about this topic? And I've said books, but please feel free to suggest a Netflix special.
There's no easy Netflix solution for you, I'm sorry. There are some books that I do, they're a little dated in some respects, but I do think that there are some fundamental texts that I've enjoyed over the years. Enid Campbell is one of them. It's written on parliamentary privilege. Gerard Carney has written a book on members' law and parliament ethics. That's a fantastic book for unpacking the historical foundations in the UK laws. There's some more recent publications. There's an interesting one. I'd have to, it's sitting upstairs on my desk, but it's a UK publication, and I should actually sort of say to you all that I'm a practitioner. You know, Clark brings to this sort of area practice, procedure, precedent, an understanding of the questions to ask, the sort of being able to spot the issue, perhaps, but you know, also being able to encapsulate the questions that you might go and seek legal advice on. And so, yeah, there was a book recently published by a number of former clerks and scholars in the UK that I found quite fascinating. So, yeah, I'll get that title for you if you like. But yeah, David's probably got it. Of course, the Red Book. I must give the Red Book a plug, and the Green Book is under consideration. And yeah, a retirement project, probably.
So the Red Book being New South Wales Legislative Council practice, there is a second edition, and you know, we've been asked to speak, but there are other parliamentary officers here in the room who also I regard as experts in parliamentary privilege. So Stephen Frappel, my co-editor on New South Wales Legislative Council practice.
Done journal articles.
And lots of journal articles on the subject. Stephen Reynolds, the Deputy Clerk of the LC, has published on this subject as well. In terms of film, if you want to delve into 1641 and Charles I, the film Cromwell is worth a look. I'm not sure what platform you'll find that on, but I'm sure it's available somewhere.
I can actually answer that because I looked it up before this evening. It's free on YouTube because it's a 50-year-old movie about Parliament. But thank you, Helen, for your more contemporary reference that we could use for this evening. Might have time for just one more question.
There's one of our audience members here who even got there early. So.
Oh, yeah. Someone got a microphone? Thank you.
Yeah, thanks for tonight. I'm just wondering if Parliament might consider each time you're about to sit to actually show one episode of Yes Minister. And alternate the following one with Utopia. And maybe suggest to the schools with the current climate in the Middle East that maybe Life of Brian could be compulsory viewing once a week. I just think it needs to be kept in concept. That we don't end up crushing too much of freedom of speech in the interest of having freedom of speech. I know it's a thin line, but I think we can be lucky that we're in our civilization that does in fact respect it, that we spent years and years getting to do it. And Cromwell was probably published by the Republicans. Okay, anyway, thanks for that.
Thank you.
Thank you. As you've said, yeah, it took hundreds of years for parliamentary privilege to develop, and our parliamentary system is continuing to evolve. We're continuing to, all of us, I think, in this room are trying to contribute in different ways to that process of trying to help perfect our still imperfect parliamentary system, but it is nevertheless pretty good. It's something we're all proud to be a little bit a part of, and to be able to serve and support this great institution is indeed a privilege. And yes, Minister is a central view. Utopia is just too hard. It's too hard.
I've got a local council.
Well, we've just come to time, so I'd like to thank the clerks of the New South Wales Parliament, Helen Minikin and David Blunt, for their participation tonight. Please give them a round of applause. For those who are not aware, this event falls in a week that is following 3 weeks of budget estimates and prior to probably the last 2 sitting weeks of this year. So amongst other big events like the Bicentennial and just business as usual. So thank you very much for your time. We really do appreciate it. I would also like to thank Mr. President for opening tonight's event and thank him for his continued support for our public programs. And I would like to thank everybody in this room for attending this evening as well. We weren't sure how many people would be interested in the niche topic of parliamentary privilege. I'm happy to see that there's many people here in New South Wales, so thank you very much. This is the last public event for the calendar year for Parliament Unpacked. But if you are interested to attend any exciting events that we have planned for 2024, please, that's right, that next year's 2024, please follow us on our social media channels or you can sign up for a newsletter. There's ways you can do that on these bookmarks here. There is another event coming up shortly at Parliament though. That's hosted by the Australian Political Studies Association, and that's on Monday the 27th of November here at Parliament at 4 o'clock. The panel discussion will explore the challenges for Parliament with reference in the conference theme of emerging from crisis into complexity. Was there anything you wanted to add to that, David?
It's a joint venture between the Australian Political Studies Association and the Australasian Study of Parliament group. We'll have 2 panels involving equal representation of academic, political scientists and practitioners, members of Parliament from here. It should be a really good 1.5 hour session, so we do commend it to everyone. You'll no doubt be able to find details on the Parliament's website.
And also here on your way out, there's a flyer that you can pick up as well. Thanks for that. I only learnt about it a few moments ago, so I wasn't totally up to date. But we have a few other things I'd like to let you know about. We'll be sending you an email shortly just asking for feedback about this event, what you liked, what you didn't like, what you'd like to hear about next time you come to Parliament. We also have 2 books for sale that have been written by Parliament staff. One is a cookbook created by our catering team. It's called Dining at New South Wales Parliament. And another book which focuses on the over 200-year-old history of this building. It's called The Rum Hospital to Parliament. We also have a free book available tonight. It's called A Fit Place for Women. If you're interested in any of those, just outside the door, there'll be Parliament staff to assist you with that. And as we are in a building that is over 200 years old, you may have noticed it was a bit of a challenge to get into the building today. When we head off shortly, there will be Parliament staff to assist you finding your way back. But basically, whatever you just did, please do in reverse. And just a reminder, the toilets are just outside on your left when you leave. Otherwise, thank you everyone. Good evening, and we'll see you at our next event. Thank you.